Now back to the show. This is AM 650's The Law Show.
Welcome back to the program. We're with Hobbs Giroday in studio. David Hobbs and Ian Giroday are Vancouver estate litigation lawyers. And the subject today, we're talking about wills and estates, of course, but we're also talking about competency and incompetency. And, let me start this segment this way. Ian, if someone comes to Hobbs Giroday and says, look, you've already said that most people who come to your firm are dissatisfied with the terms and conditions of a will. So someone comes to you and says, I'm terribly dissatisfied with the outcome of this will, mostly because I don't think the person, the will maker, who may be a relative and usually has to be, was competent enough to have organized this thing, and I want you, on my behalf, to prove that. What do you do?
Well, the first thing we're going to do is we're going to probe the evidence that the person who comes to see us has to support the notion that the will maker didn't have competence when he or she made the will.
Okay, and assuming it's got to be more than just a gut feeling, too, doesn't it? If they're that upset, they've got to come to you with more than just a full tilt rage going on, right?
Sure. I mean, the typical client or potential client that'll come in the office will have a scenario where the will was made perhaps by an elderly person with some dementia or some other disease that affects the mind. They may have earlier wills, knowledge of earlier wills that are quite inconsistent with the most recent will. There may be some evidence that the beneficiary who stands most to gain by the last will had a dominant position in the will maker's life, so there's a combination of perhaps compromised competency combined with things that raise suspicious circumstances or the potential for undue influence.
Right, okay.
And we go from there. We'll be looking for things like, as I mentioned earlier, was it a lawyer-drawn will? Can we get a file where we can look and see what sort of competency assessment was performed? Is there any evidence, medical evidence, that we can gather that will assist us in understanding where the will maker was medically?
Right.
Because even though competency is a legal test, medical evidence is very important. And we're going to be looking to see what sort of evidence we might be able to gather from people who were close to the will maker. The evidence of what we call lay people, not non-expert witnesses who may have great insight into the will maker's level of functioning at and around the time they made the will.
Okay. David, is there any kind of statute of limitations at play here? Once a person dies and this probate process begins where an executor is appointed and the courts give approval that everything can go forward, which, as Ian has already said, takes at least 6 months usually to expedite. But once all of that is in place and everything's rolling, talk to us about what happens when there's a dispute. And in other words, in terms of statute of limitations, if it goes on longer for whatever reason, and people don't even find out what's going on until much further down the road, can they be cut off because, oops, you've passed the magic line and you had to register your complaints before X number of years or months had expired?
We don't find that often because, as you can imagine, the death of an individual is usually a fairly widespread, well-known fact. There may be an obituary, there may be talk within the community, there may be other things. So I must say it would be uncommon to have someone come in to discuss the validity of a will many years after the demise of that person.
It's unlikely then. Okay.
One thing I wanted to mention to you, just in connection with what you and Ian were discussing a moment ago, is that if you're going to challenge the validity of the will, the first question you ask is, if the will is invalid, what does that mean? In relation to the person you're speaking with. So, and usually you're looking at two situations. One is an intestacy, i.e. if this will is not valid, there is no will.
Okay.
Therefore, it's an intestacy. and then you're looking at whether or not the person you're speaking to takes on an intestacy, i.e. they would be a beneficiary in an intestacy. The other situation is the earlier will. So if this will is not valid, then the one immediately before is now the valid will.
Right.
And the person you're speaking to would have to be a beneficiary under that will, i.e. the one that's going to kick in when the other will is determined to be invalid. So
otherwise, they wouldn't be in your office, would they?
They can derive no benefit from attacking the validity of the will because they're not going to take anyways.
Right.
So we determine that first, and along with their evidence and their concerns and so on. And if there's enough, our primary issue is, do we file a caveat or not, which is what we file in the registry, the probate registry. It stops the probating of that will.
Okay.
And now all the registries are on notice to not grant probate of that will. There's a problem that's now going to be investigated.
So even if there's creditors who are to be paid and there's a lineup of people who, there's a distribution thing about to take place, it just all goes on hold.
Right, because the executor won't be able to obtain the grant of probate of that will because there's been an issue raised about its validity.
Okay.
And that is going to either get resolved by a simple process quickly, or more likely it's going to lead to a lawsuit, which we call a probate action. The will now be proven in solemn form. Now, this is all a bit murky, but it kind of gets back to the execution of the will when we were talking about formalities and so on.
Right.
Because if a will is signed properly and executed properly and witnessed properly, there's a presumption that the testator knew and understood the contents of the will.
Right.
And that's why you can just get a grant of probate, because the law presumes the person's competent, they know what they're doing and so on, just merely from the formalities of the will. But if there's suspicious circumstances, that all goes, and you now have to have a trial with the anecdotal stories, the expert witnesses, the solicitor who drafted the will, and anyone else who has any knowledge that goes to, whether the will is valid or invalid.
And this is all part of my coming to you and saying there's a competency issue, this should not go forward. And so you're able to freeze the process,
right.
Take a good long look at whether my case has some validity and beyond what's in it for me. And that's certainly quite a fair and reasonable question to ask. But once it's determined that, there may be some merit to this, then you go to trial?
Yes, and the case we did, Ian and I together years ago, we brought a person into court. Now, it's a bit of a bad example because it really had to do with gifting, not with wills, but the same principles apply. But the witness, and this would not be in the case of a will, but in the case of an invalid gift, made by an incompetent person, it's the same principle, was cross-examined in front of a judge and asked questions. Do you know where your bank accounts are? Do you know who your relatives are? Do you know how much money you have? And the court got to observe this obviously incompetent person,
right,
who could not answer these questions and could not speak in a rational way.
But it's rare because usually the will and the issue of whether the person who made the will was competent or not is complicated by the fact that person is no longer with us.
Precisely, and so the first person we're repeating ourselves a little bit, but the first person we're looking at is the lawyer who drafted the will and took the instructions.
Sure, right.
And then we're looking at all the anecdotal stories, and we're looking at expert evidence, which will be of a medical psychiatric nature, which is compromised if that medical witness never met the deceased.
Sure.
Because they're forming an opinion based on a person they never examined.
Exactly. Ian, what happens, just speaking of further complicating the process, and this is what you deal with all the time at Hobbs Giroday, what happens if the will, because there's no lawyer's file to look at, no notary's file to look at. The guy went out to the drugstore and bought a will kit.
Right.
And brought it home and had the next door neighbor come over and the son-in-law come over. There's two witnesses. Bob's your uncle. There's my will. So now someone is challenging the competency of the will maker from a will kit. Right. How does that mess things up for you?
Well, if we're challenging, it's probably a little bit helpful, at least in the sense that there. I shouldn't say necessarily helpful, but here we know we don't have someone who's done the competency assessment,
right,
to see whether this will maker actually had the competency to make the will, and that's I guess that's a bit of a bit of promotion for lawyers and notaries who draft wills for a living.
Right.
There's lots of good reasons to, instead of spending $100 on a wills kit, there's a lot of good reasons to spend $500 or $1,000 to go see a notary or a lawyer, and make sure that you're getting some assessment that you're capable of making the will, and learning a few things about some of the pitfalls of will, when your will is valid, when your gifts are valid, and so on and so
Right, but
forth.
just as an aside, very quickly, just as an aside, are those drugstore will kits or stuff you download for $50 or what, are those in fact legal?
Yes, they are.
Okay. Okay.
But you have to follow the instructions carefully.
Right.
And the instructions better be pretty good. They better make, they have to comply with the Wills Act formalities, or at least instruct you on how to comply with the Wills Act formalities.
Right.
And of course, in an ideal world, they would tell you things about what happens to your will upon your getting married, or you're having a judicial separation or divorce. What happens if you decide to disinherit one of your children, and so on and so forth. And those are the things that that are typically lacking in that sort of scenario, as opposed to going and seeing a professional who drafts wills for a living.
David, how many people come to you who are dissatisfied with a will situation in which they may have been named to some degree or another, who are dealing with a will kit sort of scenario in the first place? Is that fairly commonplace, or is it still fairly rare, the fact that do-it-yourself gang?
I would put it in the 5 to 10% category, or something. So it's not uncommon. It's not the frequent thing we see. We usually see a will that's been witnessed by a lawyer or by a notary. And,
right.
But we have a case we're working on right now, which is a will kit case, and the person went to their fellow church members, the church they attended, and 2 church members witnessed the will. And the content of the will was handwritten as to the instructions, because it's a boilerplate form and you're filling in blanks.
Sure, right, yeah.
So when it got to the really important part of, like, how is this estate going to be distributed, the person just made a comment about, something about ignoring names, and then you're left to wonder, well, I wonder what that meant. And so the expression of the wishes is not in a form that a lawyer or a notary would have drafted, and therefore now we have an interpretation problem, and
right.
wonder what the will means.
Sure.
So,
Ian, when you get into court and your star witness is deceased, and yet you've got a client who insists that whatever the conditions of the will, they're wrong. Something's wrong. We need a variation. We need to change this will. And yet, obviously, the person who made it is no longer around to approve of or to contribute to the process at all. So, how do you deal with that?
Well,
you have to assume you get inside that person's head, right?
Right. On the competency side of things, you're certainly looking to the lawyer who took the will instructions. You're looking for expert medical evidence from the family doctor, perhaps from a geriatric psychiatrist.
Oh, okay.
In terms of where they were at medically. And you're looking for evidence from the people who knew the will maker best. And and which of those sort of 3 categories of witnesses is most important in any given case? It depends on the facts. It may be that the lawyer quite correctly can say, no, I did a good job, and they met the test for competency, but the layperson can say, I don't know what it was about old Bill, but he just had it in his head that his son was robbing him blind, and never came to visit him. And I saw his son there all the time, and he was the most caring guy, and there's no way he robbed him, and there's no evidence otherwise that he robbed him.
Right.
So, and the son's not in the will. Well, that's an example where that evidence will be very powerful to illustrate that the will did not will be invalid, because it was a delusion that the will maker had.
Right.
Clearly impacted the gifting he made under the will.
David, we need to take a quick break, but when you're in court and you're presenting your side of the argument on behalf of, you're applying for a will's variation, you want to change the terms of someone's will, and you have to prove competency or lack thereof, who's going to make the final call? Is it always a judge, or are sometimes juries involved?
Very rare to have a jury, not impossible, it's possible, but and I must caution myself a little bit because our rules of court do have some cases that are exempted from electing to have a jury. I don't think that applies in this particular topic, but I want to check that to be 100% sure.
Mm-hmm.
But more often than not, and much more often than not, it would be a judge-decided issue. The
Right.
judge would decide the facts, the law, and render the decision and the reasons for judgment.
Do judges ask questions? I mean, you present your side of the story. The other side presents their case. The judge listens to all the evidence and the witnesses and so on. Does the judge ever just kind of lean forward and go, by the way, and ask a question that perhaps hasn't been asked that the judge feels is necessary to come to a reasonable conclusion or decision? Does that happen, Ian?
Yes, it does. Usually they allow the direct evidence to go in, the cross-examination from the other side to go in, and then if they feel like there's something that they need to know, they can certainly ask the question, and then they'll invite the lawyers to ask any questions that arise from their questions.
Oh, okay, right.
Sort of a fairness thing. One thing I want to just say, Sterling, is you're not really dealing with invalidity or competency when you're doing a will's variation claim, however.
Oh, okay.
You're accepting that the will is valid. You're just saying that the terms of it need to be varied because they're unfair to the will's variation claimant.
Oh, okay. Well, and that's an important legal distinction to make that got right by me, and I thank you for stopping me and making it. Our guests are David Hobbs and Ian Giroday from the Vancouver estate litigation firm Hobbs Giroday, LLP. This is The Law Show on AM 650, and we'll be right back.
There's more of the show still ahead. This is AM 650's The Law Show.